Hi everyone and welcome back. You're watching The Money Show on ET Now. Well, it was definitely a landmark judgment that was delivered by the Supreme Court. This was when, of course, they did clarify that the daughters of a Hindu Undivided Family will get rights in the ancestral property regardless of whether the father or, the Karta was alive or not when the Hindu Succession Act was actually modified on the 9th of September 2005. So let's analyze this a bit more in detail. We have with us Abhishek Rastogi, the partner at Khaitan Company. Abhishek, thank you for joining us today on The Money Show. To start off with, what is your understanding of, let's just, if you could, for the benefit of our viewers who may not have read out much on this Supreme Court ruling, what is your understanding? What does it mean for the women who are co-partners in an HUF?
So basically, most of the people today understand that the Indian daughters have equal right, but that came by way of an amendment in 2015, but it gave a little effect to this entire problem. While the right of equality came to the Indian daughters, it came in a very restricted way in the sense that it gave the benefit only with effect from 2005. And that's where the problem was. As you know, that there are today a lot of controversies related to the retrospective amendment and the retroactive amendment. Supreme Court has given this beautiful order wherein the amendment of 2015 not only takes back the benefit from effect from 2005, but now gives it in effect right from the time the Hindu Succession Act from 1956 came into force. Which means what? What the problem was? The problem was that in case the death of the father happened prior to 2005, the daughters were not eligible to claim this benefit, and hence there was no right of equality in those certain circumstances. Now what has happened is, because the amendment has been given, retrospective and retroactive amendment effect has been given, the right of equality now comes onto the Indian daughters or the Hindu daughters right from 1956, which means that now the date of the death of the father, which was relevant before passing of this decision with effect from 2005, is no longer relevant. The date of birth of the Hindu daughter is also not relevant. The date of the partition is also not relevant. And one factor which has been made very relevant is that the oral partition will not be considered while determining this eligibility of the ancestral property. So in a nutshell, if I were to summarize, the benefit to the Hindu daughters have gone back irrespective of the date of the death of her father, or the birth date of the Hindu daughter, or the date of the partition, and so on and so forth. So I think it's a very, very welcome decision. The Supreme Court has beautifully gone into the retrospectivity and the retroactive analysis of this entire problem.
All right, excellent. Okay, Mr. Rastogi, I want to get one clarification in, especially for those women, who are co-partners in an HUF. Now, let's say because of, up until now, this clarification has only just come, right? But can this ruling essentially lead to give women the right to sort of drag the other co-partners to court, or use this as a subject for litigation in case if this ancestral property was maybe disposed of, prior to this clarification, and because of the rule, this whole 2005 confusion that was there? Can they now drag the co-partners to court and say that, look, you know what, you all did dispose of the property, not giving me my share, but now that the Supreme Court ruling has come, give me my, my pound of flesh, from when the property was sold, and you all shared off the proceeds between yourselves?
Yes, I think that's a very nice and relevant question, because a lot of these issues will now come up before either the lower courts or before the Supreme Court. But now, because of this decision, and this is a larger bench decision of the Supreme Court, three-judge bench decided this issue, and we know for a fact that there were controversial decisions on both the sides, but that was by a division bench of Supreme Court. So now three-judge bench has decided this in favor of the Hindu daughters. Now, of course, in light of this decision, this becomes the rule of the land as we speak. So which means that the Hindu daughters will have a legal remedy now to serve a legal notice in this case and also file a suit. And they can also go on to the court to file and seek partition. So in all of those cases, there is a legal remedy now, even if the partition of the property has happened or the property has been sold to someone else, they can drag those people also within the legal proceedings now so that she gets her share. In fact, there will be a lot of permutation combinations, whether the property could be divided, whether the proceeds from that could come easily, or if the property or part of it has been sold, the part of the sale proceeds may have gone to the other legal heirs. But all that will now be taken into consideration. And to answer your question, of course, the Hindu daughter will have a legal remedy to go to the court now.
Okay. So yes, there is a legal remedy for the Hindu daughter to go to the court, now that there is this rule that has been introduced by the Supreme Court. Okay. Another clarification that I'd like to ask you, Mr. Rastogi, is if a woman is married, she is a part of two HUFs. One will be where she's born, that's her father, her mother's side of the family, her father's side of the family. The other, I suppose, would also be her husband's side of the family. So I just want to understand that how would this entire rule fit into that scheme of things? Is it completely applicable to a married woman as well, since she's already now, by the way, a co-partner even in her husband's HUF?
We divide the entire discussion into three parts: when she's a wife, when she's a daughter, and when she's a mother. So what has happened by way of this decision is that the right of equality has been extended to the Hindu daughters, but which does not mean that if she is part of an HUF as a wife, she would be denied that benefit. That's her separate right altogether. The question which has been decided by the Supreme Court is with respect to her right when she is as a daughter. So which means that all the ancestral property which pertains to her father and her lineal ascendant or descendant, now she gets a share in that as well. So from that perspective, the Supreme Court has decided her right as a member of HUF with respect to as a wife will continue, and she will continue to get that benefit. There is no dispute on that. In fact, even mother, because even mother is a class 1 here. So even when the pre-deceased death happens of a son, even as a mother, she will get the benefit in the property of the ancestral property. So the entire thing has to be looked into for a lady from three perspectives: she being a wife, she being a daughter, and she being a mother.
One more curveball at you then, Mr. Rastogi. What about the daughter's children?
Yeah, so basically what happens is when the partition happens, if you see the Hindu Succession Act for this interstate succession, where there is no will, and with respect to the ancestral property, the property gets equally divided between the wife and the children now, which means that if there are two brothers and one sister and mother, of course, so the property goes in equal share to mother, both the sons and the daughter. So all of these will get 25% share. The share which pertains to the mother, which is the daughter in this case, will go to her kids as well. But that will, of course, go at a later stage, not at this stage right now, unless and until a partition is seen.
Okay. Now, we have had this law change quite a bit. It has come under litigation as well. The entire Hindu Succession Act, it has been the subject of a lot of litigation in the past as well. I'm sure you know that better than me as well. Do you believe that with the with the changes that come about with the law with respect to an HUF, because it's linked to the Hindu Succession Act, if individuals do want to sort of create a legal entity around their family business, are there better vessels or vehicles to do so rather than an HUF?
So whether it's an HUF or it is not, I think the important aspects of the Hindu Succession Act are as follows. One, whether it pertains to an ancestral property. Second, whether there is a will. So there is a distinction which is created with respect to the ancestral property and the self-acquired property that has to be taken into consideration. So if a man has a self-acquired property, that can go to anyone else. Now, if we see even the ancestral property, that has a very, very clear definition that there has to be 4 ascendants of male lineage or otherwise. So that whether it qualifies as an ancestral property also is a subject matter of debate. And also what also is relevant is to see that how this has been subject to partition, if at all. Because if this property has been subjected to partition at some stage, then the benefit of the of this ancestral property being going without, when there is no will, may not come. So to answer your question, whether there is an HUF or there is no HUF should not make any difference to the entire debate unless and until all the relevant factors with respect to the self-acquired property, ancestral property, partition, whether it has happened, and so on and so are addressed.
Understood. All right. So it's essentially a case of now the fact that regardless of the date of birth of the daughter, the date of the father or the karta passing away, the woman is entitled to equal rights to the HUF's ancestral property. Mr. Rastogi, really many thanks for joining us today and, answering all those questions, with respect to understanding everything about this law, past litigations, current litigations and new litigations as well that could arise because of this. I guess we'll continue to keep making new precedents, I suppose, going forward as well. We'll get in your view even then. All right. Well, I think on that note, we will take a very short break right here on the show, and when we return, we've got lots more lined up, especially on the taxation front, so don't go anywhere.